Hello and welcome to Security in Context. I'm Anita Fuentes, and today I am joined by Lisa Hajjar, member of the Security in Context Advisory Board and leader of the Legacies of the Global War on Terror research track. Lisa Hajjar is a professor of sociology at the University of California, Santa Barbara, and author of several books, her most recent one being The War in Court Inside the Long Fight Against Torture, which delves into the mobilization of hundreds of lawyers to help challenge the illegal treatment of prisoners captured in the war on terror. Hello, Lisa. Thank you so much for joining me today.
Thank you for having me, Anita.
So, I would like to start out by discussing your recent visit to the Guantanamo Bay detention camp. You have been to Guantanamo countless times. What are the reasons behind your last visit, and what's your assessment of the current situation? Are there any recent developments that you would like to highlight?
Yes. Well, the trip that I made in September was my 15th trip to Guantanamo. And I'll talk in a moment because there was some very significant developments. And that was the 47th round of hearings in the 9/11 case, which has been going on since 2012 when five defendants were arraigned. But the hearings in September 2023 were the first time the resumption of hearings that had basically been suspended in March 2022 because there was an effort to try to negotiate a plea bargain agreement because this case has just been spinning its wheels in the pretrial phase since the arraignment in 2012. So the reason, so it was very interesting to be back there again, especially since the last time I had been at Guantanamo was in January 2020. And at that hearing, again, pretrial hearings, the person testifying when I was there in January 2020 was James Mitchell, who's one of the two main architects of the CIA torture program. And so he was being questioned about the nature of the torture and the effects of that treatment on the five people who are facing the death penalty in the 9/11 case. But what made the September 2023 hearings, the first week of those hearings, which is when I was there, so interesting and important was that one of the five defendants, Ramzi bin Osheba, who has been, obviously suffering extreme mental illness and distress since he was first sort of seen in public after his years after he was kidnapped and forcibly disappeared and tortured by the CIA. And then he and 13 others were brought to Guantanamo in September of 2006. So from the first time he appeared at the first effort to prosecute the 9/11 case in the military commissions in 2007, his military lawyer at the time was already noting that he was, psychologically damaged. He was on psychotropic drugs, etc. So over the years, from that time, and especially like I started attending 9/11 hearings in 2013, and it was always, obvious that Ramzi bin Osheba was suffering some very severe mental issues. Like, for example, he would always complain that he was unable to sleep because he was being subjected to noises and vibrations in the secret prison where he and the other former CIA prisoners were held. But one of the paradoxes over these, more than a decade were these noises and vibrations. And later he started saying he was feeling electric shocks being sent into his body. Was he actually experiencing those things, or were those things evidence of like his tortured imagination as a result of what the CIA had done to him? And one of the paradoxes, which was resolved in September, was that because these detainees were formerly in CIA custody, and everything about the CIA remains heavily classified. No one could sort of, no, there was no possibility of doing independent investigations, whether of the facility where they were held or to allow him to see independent doctors or psychologists to understand what was going on. So you have over a decade of him complaining, and then the court not knowing what to do about it, but doing nothing, and the prison saying nothing is happening, we're not doing anything. Finally, in August of 2023, finally, so long in the making, or being requested, a three doctor panel of examined Ramzi bin Osheba, two psychologists and one psychiatrist, and they issued a report. It's classified, but we know the general contents, that he suffers from severe post-traumatic stress disorder with secondary conditions of psychotic delusions and other things. And so as a result of that, the first week of hearings in September, where I was present, was what the judge was going to do in light of this report. And nobody had expected, everybody kind of assumed the prosecution would just accept the fact that this guy has severe, severe mental issues, and therefore would be mentally unfit to stand trial. But in fact, the prosecution basically in court during hearing that week was arguing, well, he may have some mental issues, but he's not too mentally ill to understand that was involved in 9/11. He's not too mentally ill to understand why he's on trial or to participate in his trial. So the prosecution was trying to argue to the judge to make those findings irrelevant. However, the judge ultimately ruled, more or less accepted the conclusions of the medical report, that Ramzi bin Osheba is medically unfit to stand trial, and he was severed from the case. So as of that Friday, it was sometime in late September, the Friday when the judge issued his ruling, the 5-person 9/11 case was reduced down to 4 defendants. But one of the paradoxes, and this is something, while we were there, journalists were, we met with bin Osheba's, main lawyer, David Bruck, and asked, okay, so now that he's been found sort of mentally unfit as a result of PTSD, and the conditions of his confinement now in the present actually perpetuate, maintain, or even exacerbate his PTSD, what is the government going to do? And David Bruck was very frank and honest and said, we don't know, because this other paradox is that, bin Osheba remains in the custody of people who are the sources of his torment, and the kind of treatment that any reasoned medical or legal finding would be that he needs to be made available to him, competent psychological and medical treatment for his now diagnosed illness. But because of the fact that his brain harbors the secrets of CIA torture, he continues to be in the same situation he was before. And so it's really unclear what's going to happen to him, even just in this short period, even though he's not on trial. And of course, the prosecution is fantasizing that he can be fixed, mentally fixed, so they can put him back on trial. So it's just one little, example of the much larger madness of the military commissions.
Wow. That is really crazy. I wanted to bring up that we recently had the chance to interview Professor Mark Dembo, who is the director of the Seton Hall Law School Center for Policy and Research, which you are probably familiar with, and which elaborated and disseminated the internationally recognized series of reports on the Guantanamo Bay detention camp. So, as someone with extensive knowledge on this matter, what is your take, since you were mentioning the detainees, on the situation of the prisoners, like, Abu Zubaydah, etc., who are being prevented from being released, or who are even prevented from being allowed to depose his interrogators? What do you think the future holds for them?
Right. Well, I really want to give Professor Mark Denbo and the team of people associated with Seton Hall Law School who produced a number of reports, really groundbreaking stuff. I mean, not only did they sort of do, through Freedom of Information Act litigation, they got materials from the Pentagon and other things to kind of prove that, early on, one of the earlier people who could sort of empirically prove that Guantanamo had been set up to be a battle lab, and that the battle was for them over the minds of detainees to extract from them actionable intelligence. But that team also really proved, using the Pentagon's own sources, that the vast majority of people ever held at Guantanamo, and at its peak, Guantanamo held 780 people. The vast majority of them were sold for bounty, had no connection to Al Qaeda, and many of them had no connection to Taliban. They were just, it was sort of like evidence of what many people had suspected, was that like lots of people were just rounded up, in Afghanistan and elsewhere and shipped off to Guantanamo. And once you were in custody, it was like, if you're in custody, you're presumptively guilty on the basis of Bush administration policies. So Denbo and his team, through numerous reports, really broke that kind of false narrative about it. But someone like Abu Zubaydah, so Abu Zubaydah was one of the 14 CIA formerly held CIA prisoners, and Abu Zubaydah, he's the longest held prisoner who's currently at Guantanamo, who was in CIA custody. He was captured in March 2002, and he became, like, this was like really before the CIA had even developed its black site and torture program. But so they immediately started developing a black site, and they hired, two psychologists, James Mitchell and Bruce Jessen, to design a torture program. And so Abu Zubaydah was the guinea pig, for that program. And at the originally, Abu Zubaydah had been the assumption, and this is like, when the United States is operating without sufficient intelligence and then just assuming whatever they think is going on is true. They had assumed, erroneously, that Abu Zubaydah was like the number 3 person in Al Qaeda when he was captured. And that was one of the reasons he was targeted by the CIA and taken off to black sites. And as it turned out, and as the US government later admitted, he wasn't even a member of Al Qaeda. But because so many things were done to him, with all, like, he literally was subjected to every single torture technique that the CIA ever devised and used on other people. But then, there's nothing to prosecute him for. But Obama basically declared him a forever prisoner, that he couldn't be tried because there's no evidence, that would be, worthy, aside from the fact that he was so badly tortured. But that because he literally embodies CIA secrets, he can, he's characterized as too dangerous to release. So there is a new initiative that just was launched this month by lawyers, including some lawyers at UCLA Law School, to try to make a new run at, getting Abu Zubaydah a habeas hearing in order to have him declared, releasable. And then the question would be where he might be sent. But just to let listeners know who are not, sort of following the day-to-day thing. So as I said, Guantanamo originally at its peak had 780 people. Now it has 30. Of those 30, 3 are forever prisoners, including Abu Zubaydah. 16 have been long, for years. They've been cleared for release, but they still remain in custody. Most of them are Yemenis, because the way in which the US government regards the issue of transfer out of Guantanamo, there has to be a country that could accept them, et cetera. And then one is serving a life sentence. He was prosecuted. He didn't even challenge his, prosecution. He boycotted his trial. He got a life sentence. That's Ali al-Bahlul. And then there are one, Abdul Hadi al-Iraqi, who's already pled guilty, who's had numerous back surgeries. I mean, he is like severely handicapped, and he's already pled guilty. The question is going to be, once he is sentenced, would he be transferred to another country to serve his sentence where he might be able to get medical care that's unavailable to him at Guantanamo? And then there are 9 other people who are on trial. And then, of course, actually, I think that Ramzi Ben Al-Sheba will now become a fourth forever prisoner. So there's 4, defendants now in the 9/11 case. One of the Rashim al-Nashiri, who's standing trial in the other death penalty case for his alleged role in the bombing of the USS Cole battleship off the coast of Yemen in 2000. And then there's 3 Malaysians who are also facing prosecution. So that's sort of what's going on at Guantanamo.
So I'd like to zoom out a little bit now and talk about your book, The War in Court, which got published kind of exactly a year ago. So what are some of the main themes and debates that you cover in it? And based on your findings, how do you think we can situate the proceedings in Guantanamo within the long-term trajectory?
Well, this book is, I mean, first of all, it's written, it's not in, I mean, it's scholarly in a way, but it's written as a trade book for general readers. Because when I wrote this, it's based on 20 years of research. But when I wrote this book, I wanted to write a book that brought, to life in sort of clear and vivid ways, the kind of long, as I call the subtitle, the long fight against torture, like how this fight had happened, how American lawyers from every walk of the profession sort of were so appalled by the Bush administration's prisoner policies and then the Obama administration's prisoner policies, et cetera, that they, sort of became part of this, loose movement of a legal struggle on the legal terrain against the torture policy and on behalf of different people who'd been tortured by the U.S., whether at Guantanamo or in Iraq or Afghanistan and elsewhere. So the book really traces, this story from the beginning, like from 9/11 with some, sort of historical context, like I talk about things, provide some background for people who aren't legal scholars, like the significance of habeas corpus or evolutions in the interpretations of the Geneva Conventions or 21st century torture, et cetera. So these kinds of things. But one of the aspects of the book or my research that went into the book was I could never go to Guantanamo as a scholar. I couldn't write a research grant, dear NSF, I'd like to have, $50,000 and you can't go as a scholar. I couldn't go as a concerned citizen, but I sort of realized in 2010 that I could go as a journalist. And so that's how I've gone. So I've, in the 15 trips that I've made, I've probably spent a total of 6 months at Guantanamo, starting in 2010. But most of my trips have been since 2013 for the 9/11 case and for the Al-Nashri, the USS Cole case. And so going to Guantanamo over such a long period of time and staying as long as, if there might be rounds of hearings that would be 2 or even 3 weeks, if I could, I would stay for that time. It was, but bringing with it my sort of scholarly interest in torture and the law, it was something that enabled me to really understand what was happening in the military commissions as the primary battleground, in the fight against torture, because that is still literally the only thing that's really going on is the battles in the military commissions over how to prosecute people who were tortured. And so in particular, the last chapter of the book focuses extensively on, it's like both on the CIA torture program as it relocated to Guantanamo and the cases in which the government was trying to pursue death penalty cases against people who had been tortured by the CIA. So it really, it was published in, 2022. And so obviously there's, things that have happened since then, but I feel like it really kind of captured everything up till then. And the fact that the plea bargain negotiations, which began in March of 2022, but collapsed because the Biden administration would not support, the kind of concessions that would be needed for a plea bargain, they're back to hearings. I almost feel like, well, chapter 10 remains a really relevant way of understanding what's happening today.
Thank you so much. You also recently published an article in the annual review of law and social science titled Guantanamo's Legacy, where you trace the legacy of the prison and the military commissions across four administrations, which you kind of, some of them you mentioned already. So, could you give us a brief overview of this legacy and explain some of the main arguments laid out in this article?
Right. Well, for anybody who's not familiar with annual reviews, like there's annual review of law and social science where this piece appeared. There's annual reviews of anthropology and sociology and all kinds of disciplines. So annual review articles are basically where the author, people are invited and the author is asked to kind of survey the state of the discourse and the scholarship, et cetera. And so in some ways, I mean, I did that. Like I really was looking at shifts in scholarly, but also political discourse, or how scholarship about Guantanamo from its, creation, its opening in January 2002, how different scholars or discourses, et cetera, would be shifting or engaging with, as more and more was known about Guantanamo. So it's a little bit about, the kind of from the academic perspective. But really, some of the legacies are that, Guantanamo is a manifestation of, an approach to governing that was instituted by the Bush administration in order to really both empower the executive branch, specifically the president, and also inoculate the president's discretion from congressional or judicial oversight. That was the original, sort of driving force of the Bush administration, and Guantanamo was one of its manifestations. And although we're four administrations in, that kind of very expanded executive power, unaccountability, the difficulty of sort of holding the U.S. government to account, not only by international law, but even by its own laws, and the failures of U.S. courts, with a few important Supreme Court case exceptions, have really failed. So it's looking at how Guantanamo was built through the law, and in terms of beefing up executive power, what its consequences have been, not just for the people who were detained and tortured there, or the hundreds and hundreds and hundreds of people who've devoted years of their lives to working, whether as defense lawyers or as prosecutors or prison guards or whatever. But it is just this legacy the legacy is that it can't really be closed. I mean, so the big takeaway is people always say, oh, I didn't even know Guantanamo was open. I mean, that's sort of how I start the article. Like, yeah, Guantanamo is still open, and here's why. Because of, the completely dysfunctional domestic political situation in the United States. I mean, Guantanamo is an unmitigated disaster, legally, politically, in terms of security. I mean, we can talk about those issues if you want, but the inability to even recognize that the U.S. government made an egregious array of mistakes. Because in order to deal with those mistakes, you have to first acknowledge them. There's no acknowledgement. And so it's just this ongoing, incapacitation to acknowledge reality and make policy on the basis of reality. And yet then then there's also the rhetoric, that anybody who opposes Guantanamo or advocates for its closure or is critical about how prisoners were treated illegally under both federal and international law are soft on terrorism. And, the radical right in the United States, Donald Trump and others, sort of hold up Guantanamo as this symbol where they'd like to ship their political enemies off to Guantanamo. So it continues to have a kind of symbolic power among the radical right, which constitutes basically most of the right in the United States, at least the political electoral right. And so it's just, there is no way to deal with Guantanamo itself or even with the legacy of Guantanamo. And so that's what my article was really trying to do, is show how people can think critically about what happened, why it happened, and maybe just I would hope, of course, an author always hopes that someone takes something away, but they might take away from this piece, a way of thinking that, helps build a narrative that would facilitate in the future the closing of Guantanamo.
So before we wrap up, I don't know if you want to go more in detail into what you were mentioning earlier, or if there's any other thing that you would like to add that we haven't covered.
Well, I would say, that I think, although obviously so many other things and so many, actively violent things are happening all around the world that demand people's attention, but Guantanamo is a symbolic and material manifestation of the war on terror. And although many Americans and maybe some other people imagine the war on terror is now over, it's not over, and it'll never be over until Guantanamo is closed. And so I would just, sort of commend Carol Rosenberg of the New York Times, who is just there reporting for every single military commission hearing, and then there's other people who are tweeting about that. But just for people to, perhaps read my book of The War in Court, because it really is a history of the war on terror across a long period of time. Consider reading, my Guantanamo's Legacy piece, but just following Carol Rosenberg to understand the day-to-day developments that are just, like if you just look, what's happening now, for example, just to say what's going on this week, this is the week of October, the second week in October of 2023. It's the fourth week of hearings, in the set that I was there for the first week. And they're basically, the defense lawyers are fighting for access to the facility where their clients are held. They used to be held in the secret prison called Camp 7, but it actually collapsed. And so, they moved those former CIA prisoners into a maximum security facility called Camp 5. But the prison authorities, the military authorities who control the prison, aren't allowing the lawyers to have access to their clients to see the conditions of confinement. And so they're fighting this week in court over issues that have literally been fought over for a decade, about how lawyers can have access to their clients, can do their job defending them in a death penalty case. And so, there's so many things that one could find, distressing, but also in a kind of Kafkaesque way, sickly amusing. So it's, read the big stuff, but also be sure to follow Carol Rosenberg's reporting. And if you want the live action, she live tweets from Guantanamo too. I think it's always an essential resource.
Lisa Hajjar, thank you so much for joining me today at Security in Context.
Thank you for having me.